In this segment, we're going to talk a little bit more about the fiduciary duty of care that officers and directors owe to corporations, as well as the business judgment rule, which serves as a defense to a claim that an officer or director has breached his or her duty of care. And we'll take a look at a couple of cases and problems that have addressed the issue of whether or not the business judgment rule protects the officers and directors from a claim that they have breached their duty of care to the corporation. Let's spend just a little bit more time talking about what the duty of care requires of directors and officers. Under the Model Business Corporations Act, directors and officers must act, number one, in good faith, number two, in a manner that is reasonably believed to be in the best interest of the corporation. And finally, number three, with the care that a person in a like position would reasonably exercise under similar circumstances. Also, the MBCA requires that directors and officers must make reasonable investigations before making their decisions. And if they have breached their duty of care, they are liable to the corporation for the losses that have been caused. Now, courts have traditionally not liked to have to judge whether or not officers or directors have breached their duty of care. And what bothers them the most is number three. If judges are called upon to decide whether a director or officer has breached the duty of care to the corporation, the judge has to decide what another officer or director in a similar circumstance would have reasonably done. And judges say that they're judges. They're schooled in the law, but they're not business people. So they don't like to put themselves in the position of having to decide what another business person would have done under similar circumstances. And because of this hesitance to get in and judge what another business person should have done under similar circumstances, the business judgment rule came about. The first problem we're going to take a look at is problem number 4. Problem number 4 involves the baseball team, the Chicago Cubs. I've actually got it written down here as incorrectly as problem 9, but it's problem 4. This case is near and dear to my heart because before we had kids, for my husband's birthday, he was a huge Chicago Cubs fan. So every birthday we would fly to Chicago and we would go see a Chicago Cubs game. Several years before I knew my husband and we started going back for these games, in 1965, the Chicago Cubs were the only Major League Baseball team that could play no home games at night because the field where they played, Wrigley Field, had no lights. And they were the only professional Major League Baseball team that had a field with no lights. The president of the Chicago Cubs refused to install the lights for 2 reasons. Number one, he had a personal belief that baseball was a daytime sport. He didn't like the fact that it was played at night, so he wasn't going to encourage it. Secondly, he believed that installing lights would result in the deterioration of the neighborhood. I don't know if any of you have been to Wrigley Field, but it is unique in the sense that it's right in the city. It's not like when we go to see an Angels game or we go to see a Dodgers game and we're kind of, we drive out of the city and up the hill and into the parking lot. The Wrigley Field is just smack in this right within the city. So what people would do is we would go to nearby bars, have a few drinks, and then just be able to walk into the field and be at the game. So the president felt that if he installed these bright lights that would be on at night, it would deteriorate the neighborhood. So from 1961 to 1965, the Cubs consistently lost money. At the same time, their crosstown rival, the White Sox, that had lights and did play night games, were making money. And this irritated a lot of the shareholders of the Chicago Cubs. A shareholder sued to force the Cubs to install lights and to schedule night games. And the reason for the lawsuit, the claim that was made, was that the president of the Cubs had breached his duty of care to the organization because by refusing to install lights and letting them play night games, the corporation was losing money. So the court was called upon to decide whether the president of the Chicago Cubs had violated his duty of care to the corporation, and would he be liable for breaching his fiduciary duty. The president of the Cubs claimed, my decision not to put in lights and not to schedule night, and therefore not to be able to schedule night games, falls within the business judgment rule. So the court had to analyze the three prongs of the business judgment rule to see if this defense was available to the president of the Cubs. The first issue for the court to decide was whether the president made a reasonable investigation and an informed decision. And we don't have too much of the facts in the problem that is presented in the textbook to really know whether this was the case or not. But the court concluded that he had. He had investigated. He did know that his crosstown rival, the White Sox, were making money because they had these night games. That the president knew they were the only Major League Baseball team that didn't have lights and couldn't play night games. The court concluded that he did know those things. He made his decision in light of that information. The second issue for the court to decide was whether the president had a conflict of interest in making his decision, and the court concluded that there was no conflict. He wasn't making money on the side by not putting in lights or some other thing that might have created a conflict for him. He was just running his ball club. The third element that the court had to take a look at is whether the president had a rational basis for believing that his decision not to install lights at Wrigley Field was in the best interest of the corporation. Now, as I said, this is a very low bar. The officer or director just has to articulate something that makes sense, that for the reason they're stating shows that they believed they had the best interests of the corporation at heart. Now, the court didn't say too much about the personal belief of the president that baseball was a daytime game and not a nighttime game. But they did focus on the president's articulated concern that if lights were installed, it would deteriorate the quality of the neighborhood. Now, why would keeping the neighborhood up nice be in the best interest of the corporation? And that's for the reason I just kind of explained to you. Wrigley Field is in the middle of this neighborhood. People walk to the games, and it's a nice neighborhood. So, if the president is right, installing these big bright lights cause people to move out of the neighborhoods because they don't like having lights shining in their windows in late hours of the night, and the value of the neighborhood goes down, and a less desirable class of people move into the neighborhood. Those fans who would go to the bars and then walk to the ball game might start hesitating to do that if they felt that they were walking through a not so desirable neighborhood. And this is what the court found to be a rational basis for the president believing that not installing lights in order to preserve the value of the neighborhood was in fact in the best interest of the corporation. So in this case, the court indeed found that the president's actions fell within the business judgment rule, and the president was not guilty or was not liable for breaching his duty of care to the corporation. All right, now just a side note, this happened in 1965. In 1988, the Chicago Cubs changed ownership, and they immediately installed lights at Wrigley Field. And no deterioration whatsoever in the neighborhood. It's still a nice neighborhood. People didn't move out. The lights didn't seem to bother them that much. It didn't decrease the property values. But that just goes to show it's a low bar, the business judgment rule. All right, let's take another scenario. This again, the one we're going to talk about is from an actual case, and it's called the TransUnion case. In the TransUnion case, a board of directors voted to let the corporation be acquired by another corporation for the price of $55 per share. This often happens. You know, some company looks attracted to another company, the other company comes in and wants to buy it, they offer a price. In this case, the price offered was $55 a share, and the board of directors voted to let that acquisition proceed. In making this decision, the board gave the issue of whether they should be acquired by this other company only 2 hours of total consideration. They received absolutely no documentation regarding whether the price was adequate, and instead, they relied on a 20-minute oral report of the chairman of the board. They didn't consult any investment banker to tell them whether or not this was a fair price. And it turns out it was not a fair price at all. The shareholders sued the board of directors, alleging that they had violated their duty of care to the corporation. And once again, the board of directors called on the business judgment rule. They said that this court should not second guess the decision they made, that they were protected by the business judgment rule. In this case, the court actually rejected the claim that what the directors did fell within the business judgment rule. And the element of the business judgment rule that the court found the directors had not complied with was the requirement that they make a reasonable investigation and an informed decision. In this case, relying on a 20-minute oral report of the chairman, failing to obtain an investment banker's report guiding them as to what a fair price might be, and giving the whole matter, letting their corporation be acquired by another company, only 2 hours total consideration. The court said, yeah, this is a really low bar, the business judgment rule, but you're actually below the bar on this one. And the reason I wanted to talk about this case is because it's one of the very few published cases where a court actually found that a director or an officer did not fall under the protection of the business judgment rule. Very, very few cases out there, but this is one of them. Finally, the last case that was assigned for this chapter in this section was the case of Brehm versus Eisner, a case involving the Walt Disney Company. Now, in the syllabus, I didn't ask you to brief this case. I asked you to read it and think about the wisdom of Disney agreeing to do what it did. And we'll talk about it in a little bit more detail later. And again, this is one case that is of particular interest to me because while all of this was happening, when Disney was getting ready to hire Michael Ovitz to come be its president, I was in the middle of Hollywood and in the middle of what was going on. And everyone thought in the business that this was just a horrible, horrible decision that the Walt Disney Company was making. Everyone was just rolling their eyes. So the background of this is that the former president of the Walt Disney Company was a man by the name of Frank Wells. And he was a great president. He was a team builder. Everyone respected him. Everyone loved him. And he did a lot of great things at Disney. And tragically, one day, totally unexpectedly, Frank Wells died in a helicopter crash. And at the same time, the other head of Disney was Michael Eisner. And Michael Eisner was having some health scares. He had some heart problems. And when Frank Wells died, there was a real concern at the Walt Disney Company that if something happened to Eisner, they'd be without their two central leaders, and there'd be a leadership gap. So after Frank Wells died, Disney stepped up its efforts to try to find someone to come in, be a higher up executive within the company. And they started talking to Michael Ovitz. Michael Ovitz at the time was the head of an agency, the Creative Artists Agency, right? And he was the top guy there. He had really built that agency. The thing about Michael Ovitz is he had a very abrasive personality. The way Michael Ovitz got things done was by bullying people and threatening people. There's a very famous saying that came from Michael Ovitz that everyone talks about. I don't know if you've ever heard it, but he used to tell people, if you don't do things the way I want it, you will never work in this town again. And he would tell people he had his, quote, foot soldiers, quote, out on the street. And he knew everything that was going on. Nobody could be doing anything behind his back because his foot soldiers were out there, keeping him advised of everything that was going on. And I have a personal experience with his bullying tactics because I had a client who had brought a piece of litigation against an actress. The actress had agreed to perform in a motion picture for my client. And days before shooting was set to begin, she backed out of the project. Now, she had signed a written agreement. She had agreed to do it. And the timing of her backing out of the project was disastrous for my client because all of the pre-production that had happened, getting ready to start filming the movie, had been very expensive. My client had to build the sets, they had to secure locations, they had made agreements with all of the other personnel for the movie, the director, the producers, everyone else involved. So this actress backing out at the last minute caused them a lot of financial damages. So they filed a lawsuit against her. And what they really wanted more than money from her and damages from her was to get her back involved in the project. At the time, she's a much more famous actress today. At the time, she wasn't that famous, but she had a very famous boyfriend who was also an actor and who was represented by Michael Ovitz. So not too long after we had filed the lawsuit against this actress, Michael Ovitz called up the president of my client. And Michael Ovitz said, unless you drop this lawsuit immediately, I will never send you anyone represented by my agency. You'll never get another actor, actress, director, whoever that is represented by me. So my client sat down the phone with Michael Ovitz. He called me up and he said, dismiss the lawsuit. Michael Ovitz had a lot of power, but he used it in a very bullying fashion. So the reason we were all rolling our eyes about this decision of Walt Disney thinking about bringing Michael Ovitz in is because up until this point, Walt Disney had been run in a very collegial manner. And Ovitz's bullying personality just didn't seem to be a good fit. But nevertheless, the Walt Disney Company wanted to hire him. And in the negotiations, Michael Ovitz said, look, if you were going to have me leave my very lucrative agency, where during this time, Ovitz was making about $20 million a year from being the head of Creative Artists, and this was some time ago, so that was, it's a lot of money. He said, you're going to have to make it worth my while to leave. So not only do I expect generous compensation, but if things don't work out for me at Disney, I'll never be able to go back to Creative Artists once I've left. So you're going to have to pay me handsomely if you decide to terminate my employment. And Disney agreed to Ovitz's demand. And as we all expected, after just 1 year of employment, everyone at Disney realized that they'd made a terrible mistake in hiring Michael Ovitz. His personality just rubbed everyone the wrong way. Right? They would have things like executive retreats, where all of the executives would get on the company bus to be taken somewhere, and Michael Ovitz demanded that he had to be transported separately in a limousine. Right? That was just, it just didn't go over well. So Walt Disney Company decided they had to terminate Ovitz's employment, but they also, to their credit, determined that Ovitz hadn't done anything to justify being fired for cause. He hadn't really done anything wrong. He just was rubbing people the wrong way and wasn't working out. So Walt Disney Company decided that when they terminated him, they in fact had to pay him what they had agreed to pay him in his severance package. And that severance package, after just 1 year of employment, turned out to be over $130 million. Not bad for 1 year's work. So, needless to say, this really upset a lot of Disney's shareholders, and they sued the board of directors for breaching their duty of care to the company. And they claimed that the directors had breached their duty of care in the hiring of Michael Ovitz in the first place, in deciding to not fire Ovitz for cause, which would have meant they didn't have to pay the severance package, and agreeing to the severance package in the first place. So the court, in evaluating these claims, went through the analysis that we've just gone through with respect to the other cases to decide whether the board of directors' actions in all three of these areas, hiring, firing, and agreeing to the severance package, was within the business judgment rule. And as to all three issues, the court found that it was. So the board of directors did not breach their duty of care in any of these actions concerning the hiring and firing of Michael Ovitz. But my question to you was, regardless of legal liability, do you think that the board of directors acted prudently in making this kind of deal with Michael Ovitz that gave him a severance package of over $130 million if things didn't work out? Right? And in this case, didn't work out just after 1 year of him being at Disney. So if we were still together in the classroom, I would solicit your opinions on that question. Would you have done this? Why did they do it? Would you have done it differently if it were you? Right? So we don't have the ability to have that discussion now. So I would just cut to what we generally come about concluding. And that is, when you are trying to, you as a corporation or you as a business, are trying to encourage someone high up at another company, encourage them to leave and come over to work for you, they're taking a risk because they're established at the company they're in, just like Michael Ovitz was established at Creative Artists Agency. And when they move to another company, they're taking a risk that they're not going to last there. The synergies won't be there, the personality disagreements, just like happened to Michael Ovitz. So in order to induce someone to leave their current employment and make the leap to start something new, you often have to offer to them significant incentives for them to do so. Now, in the case of Michael Ovitz and the Walt Disney Company, those were big multi-million-dollar incentives because of the nature of Walt Disney Company, and the nature of Creative Artists Agency. But you may all, at some point in your careers, experience this as well. And I certainly have with a lot of my business clients in my practice. You will be out there practicing, working in your chosen fields, whether it's being an accountant, a manager. And about the third or fourth year of your employment, you're going to start getting calls from headhunters. and they're going to ask you if you're happy where you are because they have another opening, they're looking to hire, that they'd like to talk to you about whether you might be interested. And when that happens to you, whether it's in the 3rd or 4th year of your young employment, or when it's in the 20th year of your employment, you have to think about the fact that if you leave where you are taking a risk going over to a new situation where things may not work out. And once you leave your existing employment, it is a very rare case where you can ever go back if things don't work out with your new employer. So it's important to think about being compensated for that risk that you're taking if you were going to leave. To negotiate some kind of agreement that if things don't work out, you're going to get some kind of severance package. You have to think about this, both if it's you being the one asked to leave your current employer, but also if you are working for a company trying to induce someone else to leave their employment and come work for you. Now, if they don't ask for anything, that's great. But if they do, you have to think about giving them the security that makes them feel comfortable enough moving over to a new situation. So, even though these numbers in the Brim versus Eisner case seem crazy high, Disney actually did make a prudent decision in paying that kind of money to someone like Michael Ovitz. Now, whether it was prudent to hire Ovitz in the first place is another story. But as we say, the business judgment rule is a very low bar. And as long as the directors could articulate a rational basis for why they wanted to hire Ovitz, that's all they needed to do. And I can give you one of those rational bases right now. Michael Ovitz was the head of Creative Artists Agency. He had all of these relationships with all of these very famous actors and actresses and directors. Right? And that alone is enough of a rational basis for Disney to say they wanted to bring him into the company, because along with him would come all of these great relationships. So, sufficient to meet the business judgment rule.